Well, good morning, everybody. Welcome. My name is Adam White, and it's a real pleasure to welcome you to our conference. This is the Seaboyd and Grace Center for the Study of the Administrative State at George Mason University's Antonin Scalia Law School. Always kind of a mouthful. We're very, very lucky to be joined throughout the day by experts looking at what's happening right now and what's happening next. Often, especially those of you who come to Grace Center events, you know, often our conferences are focused on public policy, what's happening in legal theory. For this conference, we wanted to get more concrete. And so we built it from the ground up with some of the best lawyers we know, thinking clearly and creatively about what's happening now and what might happen next. Hence the title of the conference, Notice and Comment. This is a conference for lawyers, by lawyers, and I'll be introducing those lawyers throughout the day. But I want to especially thank the U.S. Chamber Litigation Center. Their sponsorship is helping to support today's conference. I also want to thank all of you who are here today. We're counting on your good questions throughout the day. And here's how we're going to do that. At some point, if a question occurs to you, get out your phone, as if you're not going to be looking at your phones throughout the day to begin with. Get out your phone and turn your program around. And on the back, you'll find a QR code. If you just take a photo of that QR code, it's going to open up a form where you can put in your question. Now, the form sort of confusingly says, enter your answer. No, enter your question. Enter your answer if you want. You may or may not use it. Enter your question. And at about halfway through each panel, we will bring up questions to the moderator to use and incorporate throughout the session. And we'll keep doing that throughout each session. So when you have questions, please send them. We'd love to include them in this conversation. And the first conversation is titled, What are the Post-Chevron courts doing? A question that's occupying entire armies of academics, entire armies of practitioners, and entire armies of judges. We're very lucky to be joined by four people who have been working and studying on these issues for a very long time. I'll just introduce them very, very briefly. We'll be joined by Megan Brown of Wiley Rein, Martinez of Latham Watkins, Maria Monaghan of the U.S. Chamber Litigation Center, and our moderator is Professor Christopher Walker of the University of Michigan. With that, I'll turn it over to Chris. Chris, thanks so much for hosting this conversation.
Awesome. Well, thanks, Adam. This is an incredible venue. I love the USC thing in the backdrop. I mean, this will probably be the only time in America's history where we can look back and see the White House and the USC. So we're talking about Chevron deference, which is something in administrative law, the most cited decision of all time that we spent 40 years loving. And then it died a couple of years ago.
Not all of us.
Well, us administrative law professors. This is why this is actually a practitioner conference and not, because you hear from us and we'll give you kind of the wrong take. But so for a long time we had this idea that that courts should defer to agencies' reasonable interpretations of the statutes they administer. It was this idea that presidents should be in control of the administrative state. At least that's how it was originally framed. And Chevron allowed for President Reagan at the time to be much more deregulatory, to come and undo a lot of what the prior administration had done. And I think it was pretty bipartisan consensus for a couple decades that this was like a good thing. And then it started to fall out of favor on the right. And we had Loper Bright the term before last, where the court came out and said, we're getting rid of this and we're replacing it with something called independent judgment that we'll talk a little bit about. So we've got this great panel here, but I want to start out with Ramon because Ramon actually argued the case. And so kind of want to get a sense of maybe reflecting back on the kind of the war stories of arguing it and kind of maybe flag some of the open questions that came up at oral argument that we're still kind of exploring today.
Yeah, well, thank you, Chris. It's great to be on such an expert panel with new friends and old, and also thanks to the Grace Center and to the Chamber Litigation Center. It's kind of been a fun opportunity over the past couple of weeks to go back and see what's happened in the case law since the Loper Bright decision. I, as a practicing litigator, I'm not encountering this as an academic, and so I sort of like am dealing with the issues as they pop up as opposed to systematically. And it's sort of interesting to go back, and it was sort of my big takeaway was like deja vu, because it felt like going back and looking at some of these issues and some of the issues that the lower courts are dealing with, it felt like my moot courts had been like brought to life. because the major issues, the major debates and ambiguities in the decision that I think the lower courts are struggling with are some of the things that we knew were going to come up at oral argument and that were probably not going to be fully resolved in the court's opinion. And so after the decision came out, when I was talking about the decision, it seemed to me like there were maybe 4 areas that we were going to need to get more information on into how the post-Chevron world was going to shake out doctrinally. One is sort of like what is the role for agencies going forward in the interpretive process, if any? The court seemed to hint at or say that Skidmore weight, Skidmore deference is a thing of some sort, but it's not clear what it is. It's not clear how determinative it can be, how whether it changes outcomes. So that's sort of like one topic that I think the court's decision left unresolved. A second is, to what extent is Congress allowed to delegate authority to agencies and give agencies discretion? And can they still do that? And if they do that, is it like the old style, kind of Chevron style delegation of interpretive authority? Is it more of a delegation of legislative rulemaking authority, policymaking authority subject to the arbitrary and capricious test? What are courts going to do with some of the language in Loper Bright that allows for some delegations? There's also some tricky language in the opinion that is not entirely self-evident how courts should apply it with respect to stare decisis. Not every decision, not every one of the 18,000 cases that it cited Chevron automatically gets overruled when Chevron's overruled, but like to what extent do courts have to rethink their precedent and rethink the legality of agency actions given the court's decision, looking backwards? And then finally, looking forward a little bit, like what are the effects, if any, of Loper Bright on other types of deference, and most importantly, deference to agencies when they're interpreting their own regulations under the Auer doctrine, under Kisor v. Wilkie. So those seem to be like the major issues that were left unresolved that were very handy for a PowerPoint. I could talk to clients and family members who are around the kitchen table about like sort of the next wave. And it's great to be here to talk about some of those ambiguities and see how they're being resolved by the lower courts with this group.
Awesome. Can I ask 2 questions that I didn't give you a heads up on, but just for fun?
Oh, please.
What was was there anything at argument that caught you off guard or that AI didn't catch in the moots? Or I'm just kind of curious, was there a surprise that you had, kind of going in versus going out?
So one of the nice things, and let me just say, my co-counsel, John Vecchione, is here.
I think you're going to say Harvey.
No, not Harvey. John is here, and one of the nice things about having great co-counsel and a great team at Latham and a great group of friends throughout who helped me prepare was the moot courts were very good preparation. I don't think there was anything that came up at argument that was totally out of left field. I do think one of the moments in the argument that I thought was interesting was an exchange that I had with Justice Jackson, and this one sort of stood out later, where we were having this kind of debate, and it turned into this somewhat deep sort of jurisprudential philosophical conversation. And I was trying to make the point that, in the Chevron context, basically, whenever you're talking about the meaning of a statute, it's like a legal question. This is in the wheelhouse of judges. And Justice Jackson's sort of framework for approaching that was just quite different from the way I was thinking about it, probably because I'm more of a formalist than she is. She has a slightly different approach. And she was almost incredulous at the idea, she said something along the lines of, are you saying that anytime there's a question of statutory interpretation that's a legal question, as if I had to say no to that question. I was like, yeah, no, that's my position. And so it was a little bit interesting to see that, a little bit of a disconnect, which sort of, I think, sheds light on the fact that what we were debating in the case, it wasn't just about a rule affecting fishermen. It wasn't just about a rule that's going to affect citizens and companies that are out there, but there were fundamental questions about sort of what law is and what judges are there to do that underlay the whole thing. So that was sort of one interesting moment from the argument.
Yeah, I like that. I mean, it also reflects kind of, in my mind, the evolution of Chevron. When it originally came up, it was kind of this idea, if there's an ambiguity, now go forth and make policy. And it became more, I think, as Justice Kennedy said in his last opinion, it's like reflexive deference, right?
Yeah.
So you don't necessarily do the hard work of figuring out what the statute means. And not everyone did that, of course, and the court tried to take it more seriously, kind of that. But it is interesting how you kind of saw that at oral argument through Justice Jackson's questions. At least that was kind of my take
and
as well.
I think, on that point, one of the things that came out as I was preparing in the case and working on the briefs and everything, there were like really great judges. I think I said this at argument, who had such different approaches to Chevron. Judge Silberman, who was more in the kind of 1980s and 1990s Scalia mold of being supportive of Chevron deference, he gave a speech or wrote a law review article where he said, like, in most of these agency cases, it's close enough. And Judge Silberman was a great judge and very devoted to the language of statute. But he said, these cases are so hard that we're basically in step two world, all the time. And then you had Judge Kethledge, who had, I think, given a speech saying he had never found a statute ambiguous to get to step two. And so there were these just different approaches, and maybe they sort of reflect evolution in the thinking even of otherwise jurisprudentially similar judges in how they were approaching these interpretive questions.
Yeah. So one other kind of surprise question is, like, was there anything in the opinion itself that surprised you coming out of oral argument?
Not really. I mean, it was obviously we didn't know if we were going to win the case. So I was, hitting refresh quite frequently in the last few weeks of June as opinions were coming out. And so I tried not to ever count chickens before they hatch. But, we thought, we were hopeful, we were cautiously optimistic. In terms of the rationale, though, I thought they were going to do something relatively similar to what we did. We had made a broad constitutional argument. We had also made an APA argument. And it seemed like the court resolved it formally on APA grounds, but I think informed by a lot of the arguments we had made about the constitutional separation of powers, the role of judges, et cetera. And I think it was sort of a unification of our two arguments there. And then I did think that there were some of these hard issues that the court was going to be able to punt on. And some of the ones that I laid out at the beginning, where I thought, these are tricky. They're going to want to say something, but they're not going to fully resolve, exactly. They're not going to give an operating manual for the lower courts on how to apply this decision going forward. And then my takeaway was, this was going to be an important decision if we won. It was going to be one that maybe, doctrinally significant shift, but also important in just continuing to send signals that the court has sent over the last decade, like sort of a vibe shift in the courts, that courts need to be skeptical of agency action in the sense that, be aware that agencies are going to push the envelope and be willing to say no in appropriate cases. And this was going to be maybe the culmination or the biggest one of the cases thus far in that line.
Yeah, and that kind of like nicely sets up what I want to talk about briefly. Then we're going to jump through those four questions. But so right after the decision came down, law professors, of course, hit their favorite, blogs and, the Atlantic. And I think one said it's the end of the administrative state. Several said nothing's changed at all, which I loved. And then there's, of course, us in the middle are saying, no, it's gonna,
Yeah.
But there's just a lot of uncertainty, and we've had a couple of years now, and was this the big change? Maybe I'll throw this to Megan. What have we seen? Was this a revolution, or is it, not quite as exciting as some folks were expecting?
I mean, I think the jury's still out, partly because this administration hasn't leaned into deregulatory stuff quite as much as maybe they could, and that would generate some of the resolution of the questions that Ramon identified, right? Like, you can see the lower courts are struggling with a lot of these questions, like, what do you do? But I haven't seen the revolution, right? Like, the regulatory stuff we do, like, I come at this from, someone practicing before the agencies a lot, and then my partners will litigate, but it's informing how we're doing the advocacy. It's certainly a dance that has shifted, right? Like, I think the terms of discussion have changed a little bit, but I haven't seen revolution yet. I don't know if that answers your question, but I feel like there is it's like a knife fight going on in some of the courts of appeals over these four issues, and then the administrative state is kind of floating above it, and I think some of us are just kind of waiting to say, okay, like, take the next big step and tee up some of these issues.
Yeah, I'm kind of curious, are we aware of any cases that would not have been brought under Chevron that have been brought under Loper Bright?
You mean in terms of plaintiffs
Yeah.
deciding to?
Yeah.
I think it's hard to tell, and that's one of the things that engaging the impact of the decision is difficult, because this is not just one data point. This is part of a trend that has been building. If you look long term, a trend towards textualism, towards greater skepticism towards agencies. Even in the short term, the doctrinal shifts that the court had been making on a bunch of different doctrines had been pushing back. And so, if Chevron were still on the books, I think a lot of the decisions might be coming out the same way, because judges would be deciding them at step one, most of the time instead of just some of the time. And now they're doing that, at least in theory, all of the time. So it's hard to kind of pinpoint. I do think, though, that with clients that I've been talking to, I think they are more willing to think a little bit big picture. They're a little bit less reticent in challenging the agencies, because I think they think that they're going to get a fairer shot, a fairer shake in front of judges. But I don't know that I can pinpoint a specific case.
I'll just throw in one thing. I think there has been some different choices on defense side. I think, and Maria, I think you are familiar with the TCPA cases. There has been, I think, a willingness to make arguments that previously had been foreclosed that now seem like you can take a shot, right? Or is a text message a telephone call? No, it's not. The statute says nothing like that. But you couldn't have done that in the past because you had an agency interpretation that would have been afforded deference. So I think there are still, people are moving and shifting a little bit. That sort of openness Ramon mentioned about people make arguments that maybe 5 years ago they wouldn't have wasted the time to make the argument.
Yeah, I mean, that's been my impression as well. Like, I can't think of any case that's been brought that wouldn't have been brought before, but how it's being litigated is different. Although I will say, any law professors in the room or watching this later, these empirical studies are really hard to do. I mean, you shouldn't just come in and compare it after and before, because agencies act differently, litigants act different, different cases are brought, it's going to be it'd be really hard to tease out the impact. On top of the fact of Ramon saying, Chevron had been dying for 10 years, and so it's hard to kind of figure where that goes from there. In the opinion itself, at least on the law professor front, we all got excited with footnotes 5 and 6. In other words, there's 2 paragraphs in the opinion where it says, where Chief Justice Roberts says for the court, well, of course.
Got my pocket, Loper Bright.
You got it. Awesome. It's like the Constitution. Oh my goodness.
Chris, we didn't go over this in prep.
No. Oh my goodness, it's awesome. Well, no, and the court, Chief Justice Roberts says, well, of course, sometimes the best interpretation of the statute is that Congress has delegated policymaking discretion to the agency. And they give a few examples, and that's kind of Ramon's one of the categories. And I'll start with Maria on this. There's this whole delegation question now, and courts are actually asking for supplemental briefing on this stuff. How do we figure out when it's the best interpretations that we've delegated? So kind of get a sense of, what are we seeing on the ground when it comes to footnotes 5 and 6? And that's not how you all frame it, but there's footnote 4 in Caroline Products for a minute. So 5 and 6.
Footnote 7 in a TCPA case.
Oh wow! Oh, that's not. But for us administrative law folks, 5 and we go by the footnotes. But so what? How are courts dealing with this delegation question?
Yeah. So let me just step back and explain exactly what the Supreme Court said about delegation in those paragraphs, because I think it'll help frame everything. So of course the court said, when it comes to deciding what the law means, federal courts decide that, full stop. But it also recognized, as Chris mentioned, that sometimes Congress does choose to give policymaking discretion to an agency. And that might happen, right, where Congress expressly tells an agency to define a particular term, or authorizes it to fill in the details of a statutory scheme, or to regulate up to certain flexible standards like appropriate or reasonable. And according to the court, when the best reading of the statute is that Congress has delegated that kind of policymaking discretion, the role of reviewing courts is going to change. So they're going to be looking at things like, is this delegation constitutional? What are the outer boundaries of this delegation? And is the agency sort of exercising reasoned decision-making within those bounds? So after Loper Bright, the central question in administrative law cases shifts, right? It's no longer, is this statute ambiguous? It's, does this statute delegate policymaking discretion to the agency? And if so, the discretion to do what? And although that might seem like a subtle shift, I actually do think that this is where a lot of the action is going to be over the next several years, because with Chevron gone, delegation just becomes a substitute terrain where agencies are going to try to make up a lot of the ground that they had lost. And of course, we are seeing agencies lean into this already. They're making the argument that, the best reading of the statute is that we get to decide what this term means. We get to fill in this detail. We get to determine what kind of law is, or what kind of regulation would be reasonable or appropriate in these circumstances. The IRS, DOL, FCC, all sort of using this playbook already. And I think that we can expect it anytime that the relevant statute uses sort of open-ended, flexible language or is really complicated and needs some implementation from the agency. And from the agency perspective, to be fair to them, that move makes total sense. Because if you can frame the statute as a delegation, you sort of put yourself back in that familiar territory that you're used to being in, where you're talking about line drawing and policy judgments and reasonableness review. And it also sort of gives them back some of the flexibility that we all thought that they might lose after Loper Bright to sort of adjust their regulatory approach over time. Because if you can convince a judge that they don't need to decide the single best meaning of the statute, but they can just decide that the agency has discretion, that really opens the door for agencies to change how they're exercising that discretion over time, which is exactly what they had been doing under the Chevron regime. So of course that leads to the question of like, what are courts doing with this so far? And I think the results are really mixed, which is I guess what we would expect at this early stage. Some courts have been really receptive to delegation arguments, and I think you're seeing that most where, you know, the statute they're confronting has sort of open-ended, flexible language, and the agency's choice looks a lot like your classic policy line drawing kind of decision, as opposed to an agency attempting to sort of redefine what the law means or how it applies. But some judges are starting to push back, and I think we're seeing that most when agencies are relying on general rulemaking provisions to try to justify like a new or additional substantive requirement. And that line is going to be pretty important going forward because many statutes, right, have these sort of general rulemaking provisions that say things like the secretary may issue regulations that are necessary or appropriate to carrying out this act or this subsection. Those provisions are usually nowhere near the sort of meat of the statute. They don't identify any particular term to define or any regulatory problem to solve. They just authorize rulemaking in general. And so our view, of course, is like that certainly can't be enough to find a delegation of policymaking discretion or authority, because if it is, we're sort of right back in the Chevron world, just under a different name. So the chamber has already filed sort of 7 amicus briefs, on this issue, laying out how we think the lower court should untangle those few paragraphs in the Loper Bright decision. And one of the big points that we keep making is that general rulemaking provisions standing alone should not be read to delegate broad policymaking authority. They might give an agency the ability to sort of fill in minor implementation details of a statutory scheme, but if the agency wants to do something more than that, like give meaning to the statute or decide that it should apply differently in a certain set of circumstances, it's going to have to point to something much more specific, some kind of statutory hook to show that Congress meant to give it that kind of discretion. So I think the key takeaways from these paragraphs for litigators is, I mentioned the central question has shifted from ambiguity to policymaking discretion. When you're thinking about challenging an agency action or defending against an enforcement action, of course you want to think really hard about what the best single meaning of the statutory language is. But I think you also want to take a holistic approach to looking at the statute and try to identify what provisions the agency is going to point to try to show the court that actually Congress gave it the policymaking discretion to decide that question. And I also think that we all need to sort of hold the line on this general rulemaking point, because if we lose on that, we're in trouble. So we need to be urging courts to reject agency arguments that general rulemaking provisions give broad authority, that the courts can just sort of step back and do these kinds of constitutional checks and boundary checks on. For Hill staffers, I think a big takeaway from these paragraphs is you should not read Loper Bright to mean that courts are never going to give deference to or see policy making discretion room for agencies. The court included them. Agencies are understandably going to grab hold, and I think a lot of lower courts are going to follow those agencies down that analytical path. So drafting action matters more than ever now. If you want the agency to have some discretion, you should say that in the statute. And if you don't want the agency to have discretion, you should be really clear about that so that, 5, 10, 15 years down the road, you're not watching a court, give the agency a lot of leeway to apply the statute in a way you never expected.
Other folks want to jump in on that, or?
I mean, I think that last point is really, really important, and I have seen, in discussions with folks on the Hill when they're trying to craft legislation, like depending on who's doing the drafting, if it's not coming from a committee that has frequently overseen regulatory work, I have seen like sloppy, unintentional drafting that you it's going to be abused in the future, and they think it means it speaks in the terms of limitation, but it doesn't. So I think it's a super important practical point.
Yeah, and if you're in Congress, like if you really want to make sure they have the agency has you say the agency shall define those terms, right? I mean that's the kind of key magic language to make sure that it's there. It's interesting. You would think agencies aren't doing this in the Trump administration. Like they are. I mean, the IRS is really aggressive right now on pushing the general rulemaking argument. And you're seeing some other agencies, but not like EPA. I mean, a lot of them are just the classic kind of move of the statute's clear and we're done, right? But you are seeing it in some, especially with some of these older statutes that the IRS has been interpreting very liberally for a long time. You're kind of seeing that kind of crack down. We'll give one example of that. Loper Bright itself, or better said, relentless, which I wish it had been called relentless. I don't know. You did a poor job there.
If we had lost, though, it would have become relentless deference, which would have been even worse.
Yeah, fair enough. But like, so in the relentless case itself, the agency actually came back and said, fill up the details. We're filling up the details. We can require these fishing boats to pay for the monitors. And I kind of found that kind of crazy, and eventually I think they stayed it, right?
Last 2 weeks
ago.
Yeah.
But if you want to see, and the district court bought it. The district court said, absolutely, we regulate against this backdrop norm that if their compliance costs are borne by the regulated, and so it's really interesting to see that move. So if you want to kind of see one example of kind of a pretty aggressive read of that implied delegation argument, that's a pretty good one. Right. Yeah.
Just on that general topic, I mean, I think I agree with everything that's been said, and I think Maria's laid it out really nicely on how to push back. One thing that's important, I think, theoretically, as people are pushing back in briefs is. And as judges are deciding these issues, I think the Supreme Court is thinking about a distinction between interpretive authority and policymaking authority, or interpretive authority and like legislative authority. And some of the decisions that we've seen that have been looking at explicit delegation seem to think that you can still delegate interpretive authority, and they're talking about the agency's power to definitively interpret. And I just think that's like squarely contradicted by Loper Bright. I think for people who are thinking about this, conceptual clarity is really important. And the only other hint, I know I'm a practitioner, which is why I'm here, not an academic, but I would just encourage, if for people who want to go deep, whether it's a judge or a litigant on this issue, Jeff Pojanowski has an article from before Loper Bright. I think it's called Neoclassical Administrative Law. And he, I think, put his finger on sort of the distinction between these types of authority and delegated authority that I think is what the court was trying to pick up on. And so I think that is a helpful resource, along with a lot of the other great academic work that's out there, in sort of how to translate these paragraphs in Loper Bright into a workable doctrine going forward.
Yeah, I'll just flag there again, maybe more an academic point, but there was another way they could have framed this that they didn't, which was to consider this mixed questions of law and fact. That paragraph could have been read more as, in other words, the legal question, what is the definition of an employee in a statute? That's something that the court has to decide. But whether a taxi cab driver is an employee or not is a mixed question of law and fact, where the agency should have deference. And Kagan in the dissent, I mean, it's like this is what we should be doing. And I don't read those two paragraphs of opening the door for that sort of move.
I think what they want to let agencies do, at least leaving aside the non-delegation problem, I think what they want to let agencies do is actually make a policy call in some instances. If the statute says the agency shall, choose either a 75 mile per hour speed limit or an 80 mile per hour speed limit, that's like a pretty clear delegation of a policy-making choice. It has nothing to do with interpreting anything. It's just about like what's better. And so I think that's the kind of policy choice that they think is allowed, at least leaving aside non-delegation issues, and is subject to arbitrary and capricious review.
Yeah, I mean, it is interesting though, like what policy versus mixed question of law and fact. I mean, they're kind of different ways of thinking about the same thing. I was thinking there's a Federal Circuit case, Lesko, that came out afterwards, where the court actually asked for supplemental briefing saying, is general rulemaking authority enough? And fortunately, the court said no, but they still actually defer to the agency. And that case was like federal worker overtime, and it said you get overtime if it's officially authorized, is the language in the statute. And the question was, is officially authorized require it in writing or not? And the court ended up saying, that's fill up the details, we're going to leave that to the agency. You could also imagine that as a mixed question of law and fact. I mean, so it is interesting. I'll be curious to see if you see more. Matthew Stevenson's got professor at Harvard, has got a great article on this mixed question of law and fact issue that would be worth 99 pages of reading along those lines. All right, so let's get to the next fun topic, which is stare decisis. I think one of the big worries before the decision was, as Ramon put it, we have thousands and thousands of decisions, probably hundreds and hundreds at least, where the agency only won because of deference. Are all these going to become undone? And because this is wrong. And Megan, I'll kind of throw this to you. What have we seen on that front?
So I think it's important to, and just like Maria did, to understand the words the Supreme Court used, right? They've got this paragraph right before the conclusion, and I think they were responding to, and Ramon can address like the Q&A at argument, but there was a lot of commentary, oh, this guy's gonna fall, this is terrible, all this 40 years of admin law, all these agency things are going to be lost and go away. So they have this paragraph that is, I think, fairly unscrutable. Once you start to dig into it, you can really sort of get down in the weeds. And it says, by overruling Chevron, we do not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specific agency actions are lawful, ... are still subject to statutory stare decisis. And that paragraph has created some real dispute between the lower courts on a few topics. And if I kind of honed in on a few decisions that if you want to dig in, there's a few really good places. But the first question that I think has been interesting to watch, that has generated a really interesting dissent by Judge Bumate out on the Ninth Circuit, is whose prior cases are we talking about? Is it Court of Appeals cases? Is it Supreme Court cases? And sort of right out of the gate, the Ninth Circuit sort of assumed, without deciding, I think, directly, all cases, all precedents. Like, we have circuit precedent about precedent, so we're going to apply our previous cases. And Judge Bumate sort of said, that's crazy, and there was other problems with the decision, but that's Lopez versus Bondi, if you want to Google it. I think Bumate's dissental is really nice. He walks through, like, a bunch of the doctrinal reasons otherwise under this paragraph, but for purposes of which court's cases he determines and says, it's Supreme Court determinations. That's what they had in mind. You leave in place the Supreme Court determinations, and the circuit courts are not bound by prior interpretations that deferred to the agencies, I think for reasons that Ramon kind of alluded to, the sort of the institutional roles, right? That's the interpretive job of a judge. So that's kind of first bucket, I think, of doctrinal uncertainty created by this paragraph. And then the second and third are kind of related. Judge Newsom in the 11th has a decision that goes, or a concurrence that goes through what is a holding. And it's a long piece. I don't necessarily recommend it to everybody, but he's struggling with what is the holding and what are we actually bound by? If you agree the circuit court precedent you have to keep. And he ends up taking the view that the prior determination that the agency reading was lawful is what you have. And I think that is disputed as well. Related to that, there's a lot of litigation about what is the specific agency action. And that was decided, there's been a few cases that have looked at that. I kind of like and would direct you to a Sixth Circuit case in the net neutrality setting, unfortunately named In Re MCP number 185. Ramon, I think, was heavily involved in that case. We were involved in it as well. And there, the question was whether the Sixth Circuit felt like a prior Supreme Court determination under interpreting a part of the Telecommunications Act in Brand X from decades ago, whether they were sort of stuck with that. The court there had said the FCC's interpretation is fine because of Chevron, and the Sixth Circuit there said, no, we're not stuck with Brand X because what was at issue there, the specific agency action, was the 2002 order. Sixth Circuit had before it a 2024 order, so they were not bound by that reasoning that had been endorsed by the Supreme Court. So you can see there's a lot of these threads that kind of cross current with each other, but I think if you read through the Bumate dissental in particular, you get a feel for the philosophical issues that Ramon was talking about, which is like, who's supposed to decide and what is our job as a judge? And I will say, reading that Newsom opinion again last night, it felt like it was very, it was a lot of technical, work to avoid the real takeaway from Loper Bright, which was like, the judges are supposed to be doing this. And if you have a question of law, the judges do it. And so that's kind of my takeaway. I think the other Skidmore and Auer questions that Ramon alerted to are pretty interesting. So we can talk more about stare decisis, but there's a lot there that I think the courts are going to battle about for a while.
Yeah, I mean, have we seen a flood of stare decisis challenges? Not really, right?
No.
There have been some. I mean, it's been litigated, but not as many as one might think. I mean, I think on this one, I think Megan's exactly right. There's sort of at least two distinct questions. Like, one is whose precedent are we talking about, and then the second one is, if a 1999 rule adopting a certain theory was upheld, and then the agency, later enacts a 2025 rule that's based on the same interpretation but is a different agency action, are you bound by the ruling earlier? Is the specific agency action like the actual regulation that was at issue in the prior case? And those seem to be the two biggest issues. I think Bumate's decision is basically right on the first one, although it does open the door to, potentially calling into question a much broader range of circuit level precedent.
Yeah, and this is one of the, Mary, jump in here.
I was just going to flag that in one case over an HHS regulation, I forget the exact details, but the 10th Circuit ruled on it, the 6th Circuit ruled on it. A lot of the judges disagreed about what counts as specific agency action. It went up to the Supreme Court, and the Supreme Court denied. Mm-hmm. So at least to me, it sounds like the court wants to let the lower court judges try to figure this out for a while longer. And so I just don't think we're sort of anywhere close to getting clarity.
Well, and I think it was interesting that, in the Bumate case, that he was dissenting from a denial of rehearing. And I think in the 11th Circuit case, there were 3 concurring opinions. And so I think there's also a reluctance at some of the courts of appeals to resolve this, because they're hard questions, right? And but I think there's an appetite for them to resolve it, and you can see it by the proliferation of these dissentals and concurrences that they're struggling with.
And the last comment on this from me, I think one of the reasons the court might not want to jump in as well is this was an issue that I think is probably especially important to Justice Barrett. She asked basically the same question of me and also Paul Clement, who argued Loper Bright, in the 2 cases that morning, which was exactly this issue, like what's going to happen to the prior cases. And if you think of Justice Barrett as being, one of the justices in that sort of middle group on the court, the middle justices tend to have a greater sway in sort of resolving some of the hardest questions that get in front of the court. She was very focused on it. It seemed like her question was coming from a place of not wanting to destabilize the law too much. And so she clearly cared about it. And I suspect that, that maybe she is still thinking through, exactly how this should be interpreted going forward. And they were fine putting this somewhat ambiguous language in the decision for now and letting the lower court sort it out for a while.
Yeah, that paragraph reads a little bit different than the rest of the paragraphs in the opinion. I think that was probably a highly negotiated paragraph, and maybe Barrett had a little bit of writing to do there. I mean, there are so many fun, academic questions about statutory stare decisis. But I'll resist that. So the next one, I think, is the one that law professors also spend a lot of time on is, what do we do now? What is it? And I will say I was not surprised, but also surprised that Ramon and Paul, in their briefing, didn't tell the court what to do. In other words, get rid of Chevron, but what do we replace it with? And the briefs were just silent on that.
We're silent.
Interesting.
I think we invoked Skidmore. We said we didn't explain what Skidmore means exactly, but we.
Yeah. In other words, are we just
definitely a solution there, Chris?
In other words, are we just going to do a de novo review, nothing? Don't look at the agency at all, or are we going to actually still do the Skidmore dance? And the court, not surprisingly, because in Kisor, Justice Gorsuch's dissent or separate opinion going against actually also embraced Skidmore. So it was already kind of there, but it was interesting that I didn't think the parties really put that out there. The court is very careful, though, to say it's not Skidmore deference. They use the word respect. And so what are we doing with Skidmore? And I'll give you a little bit of a take on what I see. When it comes to Skidmore, so the idea of Skidmore is old 1940s decision where it says that we courts defer to agencies' interpretations to the extent they have the power to persuade. Are they contemporaneous? Are they long-standing? Are they well-reasoned? Do they invoke expertise? All these kind of factors that might help us persuade. And a lot of litigators will be like, well, isn't that just a legal brief? Like, what are we doing? Like, why do we give special deference to the agency on this? Why don't we just say if they make good arguments, they make good arguments and they win? And the court didn't go there. The court kept some sort of Skidmore. And my kind of take on Skidmore is, well, one, it's whatever you want it to be, sadly, right? I mean, it gives a lot of discretion for judges to kind of impose their own view of deference. And I do think you're going to see some judges just embrace a Chevron like Skidmore. But why would it be different? Like, why would we still view the agency's interpretation as having some sort of like expert weight? And I think it goes back to, it's a canon of interpretation. It's a tool of interpretation. It's a way to figure out what meaning is. You might say, well, how does it tell us that? It's about context. So I'll give you one example where it matters a lot, the major questions doctrine. And when you're deciding whether the major questions doctrine applies, courts look and see, has the agency always had the same position? Have they ever invoked this different position before? What did they say when the statute was first enacted? And I think that type of Skidmore is going to have a lot of weight. In other words, if the agency has always had the same interpretation, a court's going to come in and say, that's pretty good contextual evidence that's what the statute meant when it was enacted. And similarly, if the agency, right after it was enacted, said, this is what the statute means, this is how we're going to proceed, that's going to have a lot of weight. In other words, so it's just one more tool of interpretation. At least that's kind of my take on that. I think it might also have weight when it's a complex regulatory scheme. In other words, these agencies help draft the statute. And if they can help explain how the statute as a whole works, and it only works if you have this interpretation, a court's going to look at that and say, yeah, you were there, you understand this, you're on the ground, you have craft expertise. I think beyond that, though, it doesn't have a role. And I'm kind of curious if you all have different takes. Like, what role should it play?
I mean, I think you've laid out a lot of it. I think there is some justification for taking seriously what the agency says on, you called it, I think, sort of standard interpretive principles of construction. But I think the court, when they're interpreting the Constitution, when they're interpreting statutes, they want to understand the contemporaneous context in which it arose. And if the agency was there, present at the creation, helping draft the statute, their voice to listen to, at least. You don't necessarily defer to them, but you give them respect and you pay attention to it. I think there's also debate on constitutional interpretation about the role of subsequent history. And in the statutory area, as we did point out in our brief, there is a long tradition of looking to consistent, contemporaneous and consistent agency interpretations over time. So I think that's certainly true. I think there's one other thing that you didn't touch on, and it sort of implicates the same Bumate opinion, is that there's almost like a procedural component maybe to the Skidmore weight idea or Skidmore respect, which is that as a procedural matter, the judges need to read it. They need to really think, it's like they have to look at what the agency's saying and consider it seriously. And so it's not like optional for them to look at it or not. Judge Bumate, in his decision that I think is really quite correct on some of the stare decisis issues, he maybe goes a little too far in the opposite direction. He says, look, if the statute is plain, you don't even need to look at what the agency says. And I don't know if he's literally means that, but the opinion says that the panel in that case, quote, should never even have consulted the agency's interpretation. And I think that's actually at odds with Skidmore and what the court thinks. I think the court thinks you should definitely pay attention to what the agency's saying, not because you have to defer to it, but because it's worthy to just hear them out. So I think there's that sort of procedural aspect that maybe is important.
Can I follow up on that? I mean, I think, wasn't the agency there the BIA, right? So I do wonder, if I'm wrong, tell me, right? I think it was an immigration appeal, right?
It was one of the.
So it was an immigration appeal.
Yeah.
And I think one of the things there is, I can see why Judge Bumate would not think that the BIA might need the kind of respect or consultation that maybe one of the technical or subject matter expert agencies would. So I think some of these cases are interesting because they're coming up in different ways. And so I think, does the BIA have some uniquely special, insight to what the definition is in the Immigration Nationalization Act? No. but maybe in other instances, that language may go too far, but for other agencies, there may be more willingness to look at what a technical or a historical regulator would think.
Yeah, I mean, I think as I understood his logic in the opinion, it was not because the agency didn't have particular expertise on that question. It was more that because he looked at the statute itself and it was clear enough, and he was like, okay, the statute's clear enough, I don't need to look beyond it. And I think ultimately that's probably the right answer, but I don't think that's a reason not to actually read what the agency said and look at their explanation.
I want to pick up on this thread because I think on the BIA stuff, I mean, I've long written, I think like there's no expertise there. Like, I mean, I've never liked the Chevron justification for immigration adjudication. But in the rulemaking context, kind of taking what we were saying, like it actually does capture original public meaning better, right? Like, I mean, in other words, if the agency went through the whole rulemaking process, listed public comments, and comes out and says, this is how we interpret this statute, this is how we're going to implement this statute. Actually, I mean, I hadn't thought of it that way, but like if it's more proceduralized, in other words, and it's longstanding contemporaneous, or if it is, it's even more powerful, right? But like this idea that they're trying to capture even the public kind of
the
view
agency
of
is
that,
like the
which is
James
interesting.
Madison of the statute. I
think that
I do not believe that. But at least they're there. At least they're there. They're a voice that needs to be considered.
I think this
and
is a fun
it's
art
artificial
article,
just to
like
ignore
rulemaking,
it.
and why we, and this gets back to some fun chenery too, like if it's done through rulemaking, not adjudication, like maybe we should think about this differently. Anyway, Maria, jump in.
I just want to add, I agree with that, but I also think Skidmore, to pick up on your consistency point, is important in that respect. I think the court in Loper Bright was very concerned with agencies flip-flopping from one position to the next, administration to administration. And that like sort of showed through in a lot of ways through the opinion. And I sort of read some of the Skidmore stuff to say we care about consistency. And so like on the one side, if the agency's interpretation has been consistent over time, maybe it should be given more weight. On the flip side, if this is a big change in position, this is a situation where we should reject sort of the agency's interpretation and not give it extra special weight. And so I sort of thought that it fit very well with the consistency through line that seemed to be throughout the whole opinion.
Yeah, I like that a lot. Like the anti Skidmore type, if it's changing its position.
Yeah.
So we got one left, and then I would definitely want to get questions. I've got lots more questions, but I want to get back. So the last one that Ramon flagged at the beginning is, what's the future of our deference? Are we going to keep Kagan's 25-step approach? What's gonna happen to our?
So we don't know for sure. I think on this question, though, unlike some of the other questions that we've been talking about, there hasn't been much sort of disagreement so far, at least on what the lower courts have been doing. I think the lower courts at the district court level and at the Court of Appeals level so far are basically cabining Loper Bright to the context of interpreting statutes. It's a little curious to me that we haven't seen more on this, because it does strike me that you have the Supreme Court in Loper Bright definitively construing the APA for the first time, and the APA language that bears on the statutory question is either identical or literally the same as the language that bears on how you interpret agency regulations. And so, one would think that having interpreted the APA for the first time in Loper Bright, there's not really a clear reason why that analysis wouldn't carry over into the context of looking at regulations. I think that some judges out there have flagged that, but I think they're basically treating this as this one's for the Supreme Court because of the fact that you have Kisor just a few years ago on stare decisis grounds in a very close 5-4 decision, leaving our deference intact. The one thing that there's an opportunity this coming term where the court might, if it wants to, get into some of these issues. There's a case that they took, I don't know if it's Baird or Beard, but the Baird case, I think, is how you pronounce it, that involves the sentencing guidelines. And the question is whether courts should defer to the Sentencing Commission's commentary, the official commentary on the sentencing guidelines. There's an old Supreme Court decision that had said, yes, you do defer, and it had used the analogy basically picking up on our deference. And it said, the Sentencing Commission creates the guidelines, then they do this commentary that sort of explains what they mean, so you should defer to it. And so the court is going to be asked by the parties to think about how these evolutions in Kisor, evolution in Loper Bright on the sort of deference to agencies, how that logic maybe carries over to the sentencing guidelines. situation, and it may give us a little bit of a sense of where the court is on the future of our deference.
Yeah. A co-author and I read every Kisor decision that cited Kisor until Loper Bright, and doctrines sometimes have to work their way pure, but at least what we saw in lower courts, it was an absolute mess. I mean, they're having a really hard time doing the 5-step dance in Kisor, and so it'll be interesting to see if the court at some point just says, let's just standardize this and make it the same as Loper Bright. There are things that are different about regulations, though. In particular, the agency is both writing it and interpreting it, which from a separation of powers perspective might make a lot of people uneasy, but from a do we actually care what they say, we might care more what they say because they actually wrote it. I mean, it's like asking Congress, what did you mean when you enacted that statute? So there's there is a weird difference there that the court might have to grapple with. So I've got lots more. Adam, do we have any questions? Or if not, I'll kind of jump in so what about agency behavior? So we talked a lot about how courts have changed and how maybe litigation's changed, but have we been able to see anything how agencies have changed their approaches after Loper Bright?
I mean, I think the general counsels and the lawyers are ascendant in the agencies. I think some agencies, at least the ones I practiced before, are really interested and open to core statutory arguments that 5-10 years ago they would have spent a few paragraphs in an order on, but now they're very much more interested. I have seen, and I think Maria's picked up on all this, the invocation of general rulemaking, and sort of they're looking for a lot more statutory hooks on which to ground what they want to do. So I've seen the ordering clauses in things expand a lot, and we're getting questions like, has the agency ever cited this before for anything like this? And the answer is no, they haven't. They're digging through the statute to find some hook. But I think the agencies, I think they're cautious in embarking on new authorities, but I don't think they're terribly fearful. And we haven't seen, I think, a lot of real hesitance in, say, the national security space or some of those areas to lean pretty hard into their statutory authorities, or what they claim to be their statutory authorities, and kind of wait and see if they're going to get real pushback, in court.
Yeah, and Maria, on the EPA front, what have we seen on that front?
Yeah, so more on the deregulatory side, I think it's been pretty interesting to watch how this has unfolded over the last year or so. I think we all remember, early in President Trump's second term, he issued a memorandum to agencies sort of directing them to take a hard look at the regulations they had on the books and decide whether any of them were unlawful in light of Loper Bright and a bunch of other Supreme Court decisions. Not much happened, so that was followed up with another memorandum from Auer, where they were sort of critical of agencies for not really taking President Trump up on this charge and sort of urging them to be more aggressive in going through their regs and figuring out what they could do away with. And as I think Megan suggested early on, we did not, despite that top-down directive, see a big wave of deregulatory actions premised on Loper Bright. But the EPA is, I think, a notable exception, especially on some big climate-related regs. So we saw them rely on Loper Bright in rescinding the endangerment finding and proposing to scale back power plant emission standards, making adjustments on Clean Water Act, or permitting for states. And I guess maybe that's not super surprising because the EPA has a long history of sort of coming out with these ambitious, controversial regs that are premised on really expansive theories of statutory authority. And that's, of course, what Loper Bright sort of put most at risk. But we're seeing similar moves in Interior. The Fish and Wildlife Service is proposing to make some changes to Endangered Species Act regs. And in both of those rescissions, they've said these regs were already upheld under Chevron. We know that we could keep them. But in light of Loper Bright, we don't think they reflect the best reading of the statute, so we're going to do away with them. And I saw another Office of Surface Mining rule that did the same. So I think the takeaway from all of this is that Loper Bright can be a very powerful deregulatory tool, but the agencies have to be willing to actually do it. Go find the regs, concede that they were based on an incorrect interpretation of the statute, and rescind them. So I think the door is sort of open for regulated parties and trade associations and others to sort of do that first step for them, right? Go to them with targets and explain to them, this is one that's vulnerable after Loper Bright, and we would like you to rescind it, because there might be some traction there.
Well,
Yeah.
you guys, Maria, just had an event at the chamber where the general counsel of the SEC basically said, people have not been showing up and asking us very specifically to rescind things. And so I think that call is out there, whether it's, Loper Bright based or otherwise. But I agree, like, it's there. You can use it.
Yeah.
There is some nervousness, right, on that front of, sometimes we can bake in settled expectations and how we structure our business operations that could be, if we start playing that game too much, it might get kind of dangerous. Yeah,
I
John?
just want to tell you that the relentless Loper Bright regulation, the secretary has asked the fisheries to pull it.
Yeah.
And they're going to have a meeting on the 23rd if anyone wants to write it up.
There we go. So, good luck.
I think on other front, like impact on agencies. Oh, Ramon, do you want to jump in on this?
No, you go ahead.
No, go first. I was going to switch
I was just
gears
going
a
to
bit.
say, anecdotally, Maria talked about the deregulatory, context. There's some things that the current administration is doing that are not quite deregulatory, but are trying to provide, additional authorization to do certain things. And just anecdotally, I've sort of seen the back and forth between sophisticated agency lawyers and regulated entities, and the sort of dialogue on like how far the agency should go. And it does seem to me that the decision is a very significant factor. And in the old days, I think the approach was often, hey, if it's close enough, it's ambiguous, we're going to win. We can just do it. We can go far. Yeah. And if you're in a left-wing administration, that means going far in that direction. If you're in a right-wing administration, the other way. But here I've noticed that there's like a breaking of sort of self-censorship on the agencies, an awareness that they're going to face Loper Bright style challenges maybe from the left, and an awareness that they need to kind of be careful and not going too far. And I think that's, whether you agree with what they're doing or not, like I think that is a testament to that's how the rule of law should work, and how it should be a real constraint on agencies, whatever your political persuasion.
Yeah, it's interesting on the inside the agency front. 15 years ago, I'm old. 10, 15 years ago, I interviewed like 130 agency rule drafters, mainly lawyers, and asked them like, what tools do you use? And Chevron was the big winner. Like, we all think about Chevron, we all think about Chevron. I did have a fair number of chief regulatory lawyers at big agencies who do rules say they don't think about Chevron at all, which is interesting. I don't entirely buy that. They do say they think about major questions doctrine though. But if you think about the role of the agency lawyer, it changes dramatically, or potentially does. Before, the policy folks would come to the general counsel's office and be like, can we do this? And the lawyer would be like, yeah, we could say the statute's ambiguous. You've got a 70% win, litigation risk is maybe 30%, but we've got a pretty good argument, and you look reasonable, just add some more stuff in there, and so let's do it, or at least you can do it, right? And now it's, do we have the best interpretation?
Yeah.
And now the agency lawyer is like, well, it might not be the best, but it's got a 10%, and so it actually does shift things a bit.
I mean, when I was in the SG's office, one of the things we would have to do is sort of help, or the Solicitor General would have the authority to make decisions on whether an agency could take a position on appeal. And so one of my jobs was to kind of liaise with the agency lawyers, and I would call them, and sometimes they'd say, we want to say X. And I'd say, well, what about this problem with the text? And there's this legislative history that cuts against you. And they'd be like, don't worry about it, we got Chevron. Literally, that was one of the things that helped shape my thinking about how it worked on the ground. I just don't think you can do that anymore, obviously.
One last sort of practice point on this. We've used the lack of deference in enforcement actions, and sort of when an agency is pursuing investigations and enforcement work using some kind of novel theory, there's a question whether, okay, if we really wanted to fight you on this, we think we could win because you do not have the right interpretation of the statute. And I have seen that kind of calibrating some of the power dynamic in those investigations. I think it'll be interesting to see after JARC-C sort of works its way out. I think there's just a lot of uncertainties right now in all of these incentives and sort of the tools the agencies have, but I've seen Loper Bright concern, moderate some of the interpretive issues that we confront in enforcement action.
We got just a few minutes left. Did you want to jump in or no? I want to zoom out a bit here and kind of, at the court right now, you have two different moves going on in administrative law. One, you have the unitary executive move, right, that the president needs to control all the agencies, at least their final decisions. And then you have kind of this anti-administrativist move, right? And on the anti-administrativist move, I kind of those I actually think are consistent. Like, president should be able to control whatever the president's power has from Congress and the Constitution. That makes sense. Like, but on the second one though, there is this. Maybe I'll use the word vibes at the court of, we don't want presidents to be able to change positions very easily. Like this kind of anti-flip-flopping, we might call it. And I kind of wonder, maybe I'll kind of throw this to Ramon, like, how do you see that plan? I mean, Loper Bright's one of those. It's strange to say that because it's going to make a lot of change right now, but eventually it's going to lock in interpretation, so it's harder for agencies to flip to a different position when there's a change of administration. But do you see other places where where the Supreme Court's doing that, and how do you think that's going to play out long term?
I think they don't like flip-flops because the flip-flops look like. I think they don't like flip-flops because the flip-flops are often historically been justified by the agencies as like, well, we have a different view of the law, and you have to defer to us on our new interpretation. And that just feels like it's a game because the law has not changed. And I think if you come at the law with a more formalist perspective that there's one right answer, one best answer, then it's just inconsistent with that to allow an agency to kind of like go back and forth and claim it's acting lawfully when it says X and then when it says the opposite of X at the same time. And so I think that's a concern. I think there's also a concern about settled expectations, reliance interests. I think, there are a couple cases this year, including one that I was involved with, that, involves the issue of to what extent can you rely, if the agency changes its mind and you've acted in reliance on their earlier statements, is there a due process problem with that? If the agency tries to enforce some interpretation against you when they had told you it was okay before. So I think the court is attuned to that and is appropriately worried about agencies taking advantage of their power to change their mind on things. That said, I do think at the end of the day, if we're talking about something that an agency is empowered to do because it has the right to make a policy choice, I think that this court is going to recognize that, if you have the Trump administration come in or the Newsom administration come in, like there is a realm in which the policies can and should change, and that's part of what's driving their view on the unitary executive thing, which is that, if you have a new president, they should be able to be in charge of the legitimate powers of the executive branch, including in the area of agency action.
Yeah, I will flag on that front. There is kind of and I think this is going to continue to develop more than as much as the questions we've just covered is when we get into what Maria's talking about with policy, when the best interpretation statute is that the agency has policymaking discretion, you are seeing what Justice Alito now calls the agency change of position doctrine, right? So even when we get to policy under the Administrative Procedure Act, before we used to say you could do the same, or at least Fox versus FCC, you can do the same, and now it's no. Like, you got to look at reliance interests. You got to see other reasonable alternatives to just changing the policy. You've got to see, are you grappling with the prior record? And it's interesting to see that even on the policy stuff, you got the court doing that. Now, does that still allow the agency to change the policy? Absolutely.
Yeah,
they just have to recognize, they have to jump through. And in particular, I think reliance is going to be one of the key points you're going to see on the policy front. How much is the industry or the regulated public doing that?
You wonder if it puts a thumb on the scale towards changes in position that are deregulatory, because the reliance interests that the regulated public may have in having to comply with all of these, sort of difficult requirements, burdensome requirements, you don't really worry that they're going to be upset or feel slighted if they get rid of those rules. But of course, if it goes in the opposite direction and they've built an entire business around having permission to do things a certain way and it changes, then the reliance interests look a lot more serious. So you also just wonder if it'll play out in that way.
And so do alternatives. I mean, it does kind of structure in a way to kind of take into account reliance. Adam's telling us we're up, so thanks so much.
Well, thank you, everybody. I want to say before we close this session, if you came in late, the video and audio for all of today's sessions will be released by the Gray Center in the weeks ahead, so you'll be able to see what you missed. Keep an eye on our newsletter. We're going to break shortly until 10:40, so we can go step back out. There's more food and people can get some fresh air. But before we go, I just want to add two more points. First of all, a great place to stay abreast of these trends around the aftermath of Loper Bright is the Recasting Regulations newsletter. that AFP puts out, a lot of good resources there. If you can't get enough of this stuff, and who can't, be sure to look up Chris Walker's most recent paper titled Proportionality in Administrative Law. It's very, very, very interesting look at what's been happening recently, and it's even more exciting than the title makes it sound. So, please read
That title was poll tested. And
please read Chris's paper, and please join me in thanking Chris and our guests.